Startacus are in Belfast and we're delighted to be talking to the team at Tughans. Tughans is one of the largest leading commercial law firms in Northern Ireland and they've been operating here in the city for 121 years. Through a series of Startacus chats, we'll be talking about many of the legal fundamentals a startup will need to know as they grow and scale their business. We're joined by James Donnelly from Tughans Solicitors. Tughans is based in Belfast, and today we're going to be talking about shareholder protection. So James, can you just start by talking about the role of a shareholder in running a business?
It's probably not fair to talk in terms of running a business for a shareholder. Shareholders are the owner of the business. So shareholders own the shares, they derive the profits from the company. In the event of a sale, they take the sale proceeds of the company. And while shareholders will take certain reserved decisions under legislation, primarily the Companies Act 2006, in terms of passing resolutions to change articles or change the names or whatever. Shareholders will delegate the day-to-day running of the company to its officers, to the board of directors. So it's the directors that will run the company and will make decisions on day-to-day matters. So sometimes there's confusion about that. Sometimes people sort of link the two as being one and the same. It's not necessarily so. Granted, there will be owner-managed companies, most cases smaller companies, but not necessarily so, whereby the shareholder and the director are one and the same. But equally, for more established companies, you may find that there are investor shareholders on board. So people who have invested into the company, they're shareholders, but they're not involved day to day. They're not a director. They're just purely an investor shareholder. So it's the board that run things day to day on behalf of shareholders. Okay,
and it would be more in a small family business. Do you think that there would be less of a link or more?
That confusion of roles between who's a shareholder, who's a director.
I
think it's probably fair to say that owner-managed companies lends itself more to small family businesses, but not necessarily so. You will see large companies from time to time that owned by the founder who set it up. He's still a director or has control of the board. So it's not necessarily small companies only.
Okay, perfect. So talk to us about shareholder protection and why is it important for a company to have or a shareholder to have?
Okay, shareholder protection is really just the rights that attach to the shares or for the benefit of that shareholder. It's really just to protect and enhance that person's investment. Two things. I think the first would be shareholder protection by virtue of the legislation, so the default position. Again, the Companies Act 2006 being the primary legislation. Things like shareholder meetings. There will be prescribed provisions which benefit shareholders and protect shareholders in saying, you've got to have X days notice for meetings. You've got to have a certain quorum. Every shareholder has got to get the same notice. So there's built-in protection there. But the second sort of limit of that is that shareholders are free to regulate matters between them as they see fit, mostly in the form of a shareholders agreement. So it's by agreement that the shareholder and by negotiation that shareholders will negotiate additional enhanced protections to protect their investment. They put their cash into the company. They want to make sure that their investment is protected. So I think probably minority shareholder protections is probably the phrase heard most often. So for example, if somebody takes a 10% stake in a company, it's minority shareholding, but it's starting to get a reasonable stake. So at that level, it's probably appropriate for that shareholder to try and negotiate, for example, to get a seat on the board, an entrenched right to appoint a director, so that in addition to being a shareholder, have the benefits of sale proceeds, profits, etc. That person is also an heir on the board. They won't have control of the board, obviously, at 10%, but there's some input there and there's visibility as to what goes on day to day. It's not only minority, I think it's important for majority as well. So it's hard to argue against the concept that certain fundamental things must be decided by a majority of the owners, a majority of the shareholders. So you will see protective provisions that say, certain things can only be decided by a certain threshold of a majority of the shareholders. It's important, Alistair, as you say, protects, enhances an investment, but it also gives great certainty. So the idea of negotiating those terms, investing and knowing the terms upon which you're investing gives certainty. It means that you can invest and you can move forward, and the chances of dispute or grievances are much less.
So certainty is the key in terms of the making sure that as a shareholder and shareholders have that protection. It gives the business certainty as a whole.
It's very important. It gives the business certainty. That's a good point, because the idea of the business is the business cracks on and develops and grows without getting bogged down by wrangles. I mean, you often hear it said that the idea of a shareholders agreement is, you negotiate it, you try and cover all the things at the point of investment, then you put it away, and you're not running back to it every 2 weeks. Certainty is important.
Certainty. So James, why should you protect the share value of your business?
Very simply, the share value is the value of the company. So I think that's, in most cases, that will be the reason why somebody started a company or somebody invests in a company, in order to grow the thing, to maximise value, whether that's with a future view of an exit, or as we see here in Northern Ireland, lots of family businesses, people grow companies with a plan to succession planning, family members, to bring them on board, to create legacy. So it is important. On a practical level, the share value is directly related to the financial and trading performance of a business or a company. So where performance isn't good, and customers or suppliers have visibility of that, through accounts filed at Companies House or whatever, that can make trading difficult. Can make customers and suppliers nervous of trading with the company. It can make tendering for new work difficult to get through the tender process. So it is important. It's hugely important.
Hugely important. One would imagine it's quite a complex situation to be in. So you need legal advice, support pretty early on this process as well.
Yeah, I mean, the value of the company, again, it goes back to this certainty point. So it is important to do things right, to do it right at the start. So then you move on from the legal process, your structures are there, people are clear where they stand, people have defined roles in who moves, which element of the business forward. But at a certain stage, the business has got to look after itself. The guys have got to go out and sell product and governance. I mean, yes, they've got to sell product. It's important that governance continues throughout the duration of the company. So regular meetings, well-organised meetings, board packs, etc. So people are clear, well-managed company.
And again, coming back to that point of clarity, that's really important, obviously, in terms of the running of a business as well, full stop. James, finally, let's talk about the fundamentals that need to be included in a shareholder agreement. Can you break that down for us?
Okay, so shareholders agreement is shareholders are free to regulate matters as they see fit between them. So the shareholders agreement is a private agreement between the shareholders, often put in place at the same time as updated articles of association, which are the public document which dovetail with the shareholders agreement but are filed at Companies House. Where you have got more than one shareholder, you need to have a shareholders agreement. It's the constitution, it's the rules of how the company is governed. Even in family businesses, even though the members of the family, or particularly perhaps in family businesses, you need to have a shareholders agreement in place. In terms of key provisions that you might see, and in no particular order, the board composition, as I mentioned earlier, is important. The board controls day-to-day operations, so it's important that there's visibility as to how it's comprised, when meetings are held, what's quorum, etc., because that's where day-to-day decisions are made. Majority decisions, so you will often see a majority consent clause which lists out 30 or 40 really key fundamental things which the company mustn't do without the consent of a certain threshold of shareholders. So the company won't dispose of its assets, it won't charge its assets to the bank, etc., without having that consent from a majority. Concept of drag along, you may have heard of. So concept, again, a majority protection of not letting a minority shareholder block a potential good exit. So in the event that a third-party purchaser comes along, third-party purchaser will only ever be really interested in acquiring 100% of the share capital. But if that purchaser has made an offer which the majority think is a good deal, it's right that a majority should be able to drag along that minority shareholder at the same price. So the minority shareholder gets the same price per share, but it just means that somebody with 2% doesn't have the ability to block a good company sale. Other key terms: restrictive covenants, non-compete, non-solicitation. It makes sense that people shouldn't be a shareholder and then competing with the business or soliciting customers for some other business. And then good leaver, bad leaver. So shareholder will want to understand who is running the business. So the founders perhaps, or who are the executive shareholders or managers that are in there day-to-day running the business, because they will want to understand that those people are locked into the business. They're committed to the business for at least a period of time, perhaps 3 to 5 years. And it's appropriate that if those people don't honour their commitment and stay and drive the business for 3 or 5 years, that there are some penalties on those people. And that would take the form of bad leaver provisions, where the shares may be bought back from those people at a discounted price because they haven't done what they said they would do. And then perhaps last sort of core, preemptive provisions. So preemption in terms of the issue of new shares or the transfer of existing shares. It's important that those provisions are there. So in the event that new shares are to be issued or shares are to be transferred, there's a mechanism whereby those shares are offered to the other shareholders, the existing shareholders first, before they're offered to third parties, so that people have the ability to participate on a pro rata basis according to their shareholding to maintain their percentage shareholding in the company.
So, to summarise, would you say it's fair to say that a shareholder agreement protects, of course, the shareholders, it protects also the founders of the business, but one assumes it would protect the business as a whole?
I think that's right. I think it's probably those three things, Alistair. And again, I go back to making sure you put in place it at the start, so it's there, there's no dispute, it's in black and white, and then moving on with certainty without running back to it all the time.
Great stuff, James. It's been a pleasure chatting. So thank you for your time, and obviously we wish you well for the future.
Thanks, Alistair.